Welcome back. This is the second part of a series of videos explaining the recent Google Books settlement. The slides for this presentation are available at my website, and an article accompanying this video will soon be available at ssrn.com. In the first part of this presentation, I addressed the scope of the settlement agreement, some important structural features of the agreement, the registry, the treatment of orphan works, and the basic financial terms of the settlement. In this part, I will look more closely at the various rights and permissions the settlement creates and review what the settlement actually allows Google to do with the millions of books covered under the agreement. The agreement authorizes Google to digitize books and inserts obtained from any source and to use that digital information in accordance with the agreement. The license applies to all books and inserts covered by the settlement. However, Section 3.5A1 provides that for at least 27 months after the settlement is finalized, a rights holder can direct Google to remove his or her book from the database. If that direction comes after the first 27 months, Google will try its best not to scan the book, but the book won't be removed. With the exception of works that have been removed pursuant to Section 3.5A1, all covered works are subject to digitization and may be listed in an initial search result page. The extent of information accompanying that listing, however, depends on a host of factors, beginning with the display-no display classification. Much of the agreement revolves around the distinction between display and non-display uses, and the accompanying categorization of books as either display or no display. Non-display uses are uses that do not display expression from digital copies of books or inserts to the public. The display of bibliographic information and important data about a book, such as which pages match a particular search query, the book's key terms and chapter headings, library collection information, are all considered to be non-display uses. In addition, the use of digital copies of books for Google's internal research and development is also considered to be a non-display use. Thus, whether a book title appears as part of the initial menu of search results corresponding to a user query does not actually depend on the classification of the book as fit for display or no display, but critically the extent of information accompanying the basic book listing will depend on that categorization. If a book has been classified as a display book, its listing will also be accompanied by a brief snippet of about 3 or 4 lines of text from the book. The distinction between display and no display works becomes even more apparent on the individual online book pages. Once a user selects a particular book as the object of their investigation, they will be directed to an online book page dedicated to that book. In the case of no display books, the online book page will simply contain bibliographic information and data about the book consistent with the definition of non-display uses. The online book page for a display book will feature up to 3 snippets of 3 or 4 lines of text each, per search term per user. In general, the display books will also permit an extended preview of the work. If a work is subject to the standard preview, the pages selected for display will depend on the relevant user query. The default standard preview is limited to no more than 20% of the book's pages and no more than 5 adjacent pages for non-fiction works, not including the book's table of contents, title page, copyright page, or index. The default page limits for works of fiction are slightly different, set at 5% of the work and no more than 15 adjacent pages, with an additional stipulation that the final 5% or the final 15 pages of the work must be blocked from view. These are merely the default setting. The agreement allows a rights holder to exclude any book from one or more of the display uses. In addition, the rights holder can also change the classification of a book from display to no display at any time, which amounts to a complete opt-out from all display uses under the agreement. Rights holders have the option of selecting a fixed preview or a continuous preview as an alternative to the standard preview. Under a continuous preview, Google is authorized to display up to 10% of pages without the adjacent page limits in the standard preview. Under the fixed preview mode, an initial selection of no more than 10% of the work is made available for preview. This selection does not vary according to the user query being performed. In all three search modes, standard, continuous, and fixed, a rights holder may choose to increase the percentage of the work made available up to 100% of the work. Everything we've discussed so far is really just a variation on the Google Book Search in its current form. However, the settlement also opens up a whole host of new opportunities for Google and for copyright owners with respect to their works. The first of these new opportunities is the consumer purchase model. The agreement allows Google to offer access to display books to the general public as consumer purchases. This system would allow users to view, copy, paste, and print books within certain parameters. Under the consumer purchase model, users will also be able to make book annotations for their personal use and to share those annotations with a limited number of people. As a security measure, printed pages will also include a copyright watermark. The consumer purchase model envisages two pricing options: either a settlement-controlled price determined by Google's pricing algorithm, or a price specified by the rights holder themselves. The pricing algorithm will be designed to maximize the revenue accrued to each individual rights holder, not the total revenue to Google. And the rights holder can change his or her pricing option at any time he or she wishes. The agreement defines a set of initial pricing bins and works are to be distributed among these bins as depicted on this graph. These bins and their distributions are subject to renegotiation by Google and the registry at any time. The agreement contemplates offering schools, universities, and corporations the option of an institutional subscription to Google's catalog of digital works. These institutional subscriptions will allow online access to and viewing of the full contents of all display works in the Google Book database, unless, of course, the rights holder has opted out of this particular use. Institutional subscriptions will enable users to view, copy and paste, and print pages of a book, and may also enable book annotations. The financial terms of the proposed institutional subscriptions have already proven to be controversial. The settlement agreement provides, somewhat cryptically, that the pricing strategy for institutional subscriptions will be governed by two objectives. One, the realization of revenue at market rates for each book and license on behalf of rights holders, and two, the realization of broad access to the books by the public, including institutions of higher education. This, of course, makes no sense. These twin objectives, maximizing revenue and maximizing public access, can only be consistent up to a point. At the end of the day, Google and the registry have to choose one or the other as their primary objective. The agreement indicates that the pricing for institutional subscriptions will be determined in reference to comparable third-party products and services, the scope of contents of the books available, and the quality of the scans and other features offered as part of the institutional subscription. Prices for these institutional subscriptions will vary depending on the size and nature of the institution in question. It seems clear from the agreement that Google plans to divide up the market into segments to facilitate price discrimination. As the settlement itself notes, segmenting the market in this way will make it easier to reconcile the conflicting objectives of maximizing revenue and maximizing public access. The agreement also contemplates a different form of price discrimination based on offering specialized versions of the institutional subscription database. Google is required to ensure that the price for access to the entire institutional subscription database is less than the sum of prices for access to any specialized subset of that collection. This is the end of the second part of the analysis of the terms of the Google Book settlement. In the next part, we'll continue on examining the rights and permissions granted under the agreement, and particularly look at public access service, page-by-page printing, the research corpus, and the new revenue models alluded to in the agreement.